Well, thanks everybody, and thanks for Leah and the rest of the folks here at UNLV for what looks like so far to be another excellent WIPIP, and for allowing us to hijack the remainder of your lunch session. This marks maybe the 18th mostly annual evil twin debate brought to you by the IP Institute at the University of Richmond. The series is founded on a notion that kind of emerged from the discussion with Mark that, people are incredibly supportive and friendly with one another even when we disagree on important issues of policy. So the series aims to bring together pairs of scholars who disagree on an important IP topic, but who can air their disagreements in a friendly exchange. So our motto is sort of serious in substance, but lighthearted in tone. Today's twins are Melissa Wasserman of the University of Texas and Saurabh Vishnubhakat of Cardozo. Their topic is inspired by recent Supreme Court cases, but the title of the debate is inspired by early 80s songs. So the title of today's debate is Patent Office Power in the New Agency Landscape, Under Pressure or Crazy Train. So what we're going to do to proceed is we're going to have Melissa briefly introduce the topic and present her side of the argument for about 15 minutes. Saurabh will then get up and have 18 minutes for his side. Melissa will rebut for about 3 minutes. I imagine that's going to take us to about a quarter of. If we end earlier than that, we might have time for a little bit of Q&A. But to get us started, in the tradition of serious in substance but lighthearted in tone, we're continuing a tradition under which instead of asking each speaker to send in their bio, we ask each speaker to send in a bio of the other speaker, which I shall now read. So here is Melissa's bio of Saurabh. Saurabh is a professor of law and director of the IP and Information Law program at Cardozo. He's an expert on intellectual property, patent law, administrative law, civil procedure remedies, and apparently the TikTok case, like the rest of us. Some say Saurabh's real expertise, however, is in his fashion sense, which includes a wide range of bow ties and the occasional ascot. He started his academic career at Texas A&M, a school that, despite what Bobby Idea claims, will never be the #1 ranked school in Texas. Saurabh also somehow became professor of engineering at Texas A&M in what I can only assume was the little-known department of men's neckwear and mixology. An interesting fact, Saurabh carries a recipe for an obscure cocktail on his phone, and if you go out to dinner with him, he will show the recipe to the waiter and ask them if they can make the drink. He's a prolific scholar, spent a stint at the PTO before joining academia, and has a knack for picking important and timely research topics. He's the king of the 2-word law review article title, wherein one of the words is patents. His article titles include certain patents, expired patents, invalid patents, stupid patents, and ridiculous patents. He's also written extensively on adjudication at the PTO, which is the subject of today's debate, a topic dear to my heart and to the hearts of exactly 5 other people. He's an excellent connector of people. He knows everyone in academia, practicing lawyers, government lawyers, and is always happy to provide introductions. I don't think there's a joke there. I think Melissa actually meant that part. Finally, Saurabh teaches civil procedure, administrative law, and patent law at Cardozo. His students rave about his ability to work Simpsons references into every class, no matter what the topic. I personally will be deeply disappointed if he doesn't work in at least 10, we should count them as we go along, 10 Simpsons references during today's debate. All right, so here's Saurabh on Melissa. It is not only a privilege to debate Melissa this afternoon, it is a contractual obligation. Melissa Wasserman is the Charles Tilford McCormick Professor of Law at the University of Texas, and she is many other things: a brilliant scholar, a beloved teacher, the voice of Siri, a seat filler at the Austin City Limits for some reason, a generous mentor and a gracious colleague. Simply put, Melissa is the good twin. But let us for a moment put aside good and evil. When you have twins, what you really have is never-ending competition. And to take an old song and turn it on its head, anything Saurabh can do, Melissa can do better. Saurabh is the 3rd best ping pong player on the Cardozo faculty. Melissa is a competitive tennis champion. Anything he can do, she can do better. A few years ago, Saurabh visited the beautiful campus at Princeton and left with some selfies and a t-shirt. Melissa visited Princeton and left with a PhD in chemical engineering. Anything he can do, she can do better. He used to teach at Texas A&M. She teaches at, well, that one's probably a tie. Ooh, it's on. But there's no doubt that Melissa is the real deal. She has testified before the Senate Judiciary Committee and the Federal Trade Commission. She's a public member of the Administrative Conference of the U.S. She is a former director of the American Law and Economics Association and serves as a referee for nearly a dozen high-impact journals. She speaks and publishes so extensively that we might be forgiven that she actually does have a twin hidden away somewhere, like that Christian Bale movie about the magicians, and David Bowie was also in it for a while. And so, Saurabh says, in conclusion, just like David Bowie, Melissa will take the position today that patent office power is, should we sing it? Under pressure. Okay. And with that, Melissa, you're up. Thank you.
So I'm delighted to be here today. So what I'm going to do with my comments is just kind of set the landscape a little bit about what's been going on in administrative law and how this intersects with the Patent and Trademark Office. So everyone knows of Chevron, right? The Supreme Court case that expanded the deference or the sphere of mandatory deference and the famous two-part test, right? You look at the statute, you see if it's ambiguous, right? If the statute's clear, you go with that meaning. If it's not clear, you defer to reasonable interpretations. Then what you had after Chevron came out is regional courts didn't know when it applied. So in 2001, you had the Supreme Court come out with Meade. And in Meade, it tried to state when was the Chevron framework supposed to apply. And the court said it's when Congress wanted the agency or granted the agency the ability to speak with the force of law. And a very good indicator of such an ability to speak with the force of law is if Congress granted the agency notice and comment rulemaking authority or formal adjudication, okay? So what did that mean for the PTO? Well, we all know, no one really thought, right, or thinks that the PTO was granted broad substantive rulemaking authority over the patentability standards or over the trademark, right, standards for registration. But everyone agreed, right, that the PTO had been granted procedural rulemaking authority, right? And so they should be, right, being given deference, right, Chevron deference when they promulgated procedural rules. But what about formal adjudication, right? Was the agency ever granted that authority? And so if you look at the TTAB, it was an administrative tribunal within the Trademark Office, right, that has 3-member panels of administrative trademark judges that preside, and it looks pretty formal-like, right? You could have hearings, right? They had the evidentiary rules of procedure that governed it. And same thing on the PTAB side, right? When those came about with the American Invents Act, right? These were these regulatory adjudicatory decisions with 3 administrative patent judges that again looked formal-like, governed by the federal rules of civil procedure, allowed for oral arguments and discovery, etc. Now, were TTAB and PTAB actually APA-governed formal adjudication? Probably not. Right? They did not, and they were not overseen by administrative law judges, which are different in type than these administrative judges, administrative patent judges, administrative trademark judges that have less protections than ALJs have. And historically, too, they didn't have director review, right? The PTO director didn't have the ability to review them, although they were recently given that, both on the trademark side and on the patent side. So what were they? Right, I think they were probably what we best thought of as administrative law, what we call Type B adjudication. These were, if you look at the American Invents Act, they required an evidentiary hearing. They did not use these magic words on the record, which we normally want in administrative law to say it was formal adjudication. And these Type B adjudications can be actually more formal than APA-governed formal adjudication. And the Supreme Court had given Chevron deference to these kind of Type B adjudications, most famously in immigration. Okay, so that was kind of the lead up, right? What did the Federal Circuit do with all of this? Well, when they came about, right, they initially said no de novo review for all legal interpretations that came out of the Patent and Trademark Office, and they adopted that precedent from its preceding court. And then, right, after Chevron came out, right, the Federal Circuit did not immediately review this decision. They just let it stand. And then it wasn't until 1993 that the Federal Circuit applied Chevron deference to a TTAB interpretation of an ambiguous provision of the Lanham Act for the first time in Eastman Kodak versus Bell and Howell document management products. Court did so without any discussion of the preceding 9 years, really didn't do any analysis, which is kind of like Chevron applies here, and perhaps not surprisingly, didn't have a lot of effect on the precedent of the Federal Circuit moving forward, right? Kind of issued, and then they just ignored that case. Interestingly, in the same year in 1993, the Federal Circuit held in Merck v. Kessler that basically the Patent Office's legal interpretations of the Patent Act received no deference. Chevron didn't apply because the agency wasn't granted substantive rulemaking authority. At that time, that wasn't a crazy decision, right? In 1993, all the regional courts couldn't figure out what to do with Chevron, and there were a number that said, look, if the agency didn't have substantive rulemaking authority, we're not going to give them deference to their legal interpretations. However, in 2001, when Mead came out and pretty clearly said, look, it's either a grant of rulemaking or formal adjudication, that's a very good indicator that Congress meant for that agency to speak with the force of law, you would have expected, or I would have expected, the Federal Circuit to kind of revisit this precedent, and it never did. Right? It never gives or doesn't tend to give Skidmore deference. It still does de novo review of legal interpretations. So all of this leads up to now we have Loper-Bright, right? So Loper-Bright came out in the Supreme Court, overruled 40 years of Chevron deference standard and a landmark 6-3 ruling. And in Loper, the court said Chevron deference defied the command of the Administrative Procedure Act. The court held that under the APA, courts are required to exercise independent judgment to decide whether an agency has acted within their statutory authority rather than to defer, right, to the agency's interpretation of ambiguous statutes, right? And John Duffy kind of argued this, right, a long time ago, and the court signed on. So what does this mean now for the PTO, right? They never really got Chevron deference, or they never got deference for their legal interpretation, so nothing's going to change there. We're just going to stay. Maybe the court will consider giving them Skidmore. It's not clear. But on the procedural side, we may see some changes, right? They used to get Chevron deference, right, for procedural rulemaking, right? And they have broad procedural rulemaking over like the patent process and the trademark process, and they were given authority for fee setting and how they run like PTAB and TTAB proceedings. But even there, I would say the Federal Circuit's not just really, or beforehand, didn't embrace Chevron, right? You could look at some of their opinions like Quozo, which was about what was the claim construction that should be utilized at PTAB, and they kind of would get to Chevron as like their last reason, right, to uphold it. And you compare to how the Supreme Court approached it, which they kind of led with Chevron, and it was like, this is an easy case, you're going to defer here. But even within procedural questions, I think the Federal Circuit's been pretty limited at the deference they give. So in particular, right, the Federal Circuit has stated that AIA granted authority to the director to promulgate regulations that govern the conduct of IPRs. And so they haven't given them Chevron deference when they would announce regulations in PTAB proceedings, right? They said you had to use rulemaking in order to get that, right? And so all of this means is I don't think like we're gonna see a whole lot of change after Loper-Bright because Chevron really wasn't a big part of the deference standard that the PTO got. Now we may see, for example, less procedural rulemaking, right? Maybe agencies, if they think they're not going to get deference, may be less willing to use rulemaking, and maybe that's not a great thing, right? A lot of administrative law scholars would prefer for policy to be made under rulemaking. We think it's more transparent, right? It might be a better vehicle. It's clearer what they're trying to announce than to do it through adjudication, although we historically have agencies like the NLRB that almost exclusively use adjudication. So that was kind of a big wind-up to be like, not sure we're going to see a lot of change in Loper-Bright. The other topic that I want to touch on, right, that's a big deal and that we've been spending a lot of time in the administrative law is to think about adjudicatory independence, or the independence of agency adjudicators, right? So if you look at the standard model of agency adjudication and you look at the APA-governed formal adjudication, I want to highlight two things. What you have is an ALJ who's pretty independent, right? They overlook the trial. They're almost like a little trial judge, right? They overlook the adjudication that's going through, and they have a lot of protections in the APA to be independent, right, to make their own decisions without interference from higher-ups. The other thing you see in APA formal adjudication is then whatever decision they make is a lot of times subject to de novo review by the agency head. So we say, look, you lower adjudicator, do it completely independent, and then the director can basically reverse you for any reason that they want to. However, they have to do it, or that political control that we put in the director, right, is done in a very specific and circumscribed way. They can reverse the adjudicator's decision, but they have to write a written decision, right, and it needs to be transparent for the reasons as they're reversing. Now, what's going on right now is there's growing concern that agency adjudicators' decisional independence is being threatened by giving greater political control over agency adjudication. And I think this careful balance that was struck in the APA is being disturbed. So a big part of this threat has involved a whole series of Supreme Court recent precedents on the Appointments Clause and the separation of powers. And these precedents have strengthened presidential control over agency adjudication at the expense, I think, of decisional independence of agency adjudicators. But it's a certain type of political control that's been strengthened, not over the final decision by basically being able to reverse for any reason, but arguably over the decision-making process of the adjudicator themselves. And so the courts have these two interrelated issues, hiring and the removal of agency adjudicators. The court's decisions associated with agency adjudicator hiring have resulted in increasing agency head control over adjudicator hiring. And critics are concerned then, right, that adjudicator may no longer be based on or hired on merit, but maybe particularly political affiliations or viewpoints, right? The second is these court precedents are associated with removal have increased the latitude of the president to remove agency adjudicators by rolling back removal protections of agency adjudicators. And so the concern there is if you can be fired at will as an adjudicator, that you're going to get some top-down pressure to decide a certain way, right? And then that could affect your actual decision-making process, and that is not transparent, right? They're not going to write in their opinion, the director wants me to decide this way, so I'm doing it, right? But you get some hidden political control that's imbued. And we think this is kind of problematic, right? Because this is a very different type of political control in the decision-making process than the review that we see in this APA formal adjudication, right? And additionally, how these precedents interact, basically, the easier it is to fire adjudicators and then the easier it is to hire, you could imagine getting rid of massive amounts of adjudicators and getting new people in, right? So this all came to a head for the patent system a little bit in Arthrex, right, where the court held administrative patent judges cannot have both final decision-making authority and statutory removal protections because they were seen as principal officers. And as part of the American Invents Act, Congress had empowered APJs to resolve certain patent questions without plenary review by the principal officer, meaning the director, okay? So the Federal Circuit reasoned this was unconstitutional, and they corrected this remedy by basically severing the adjudicator's tenure protections, making them fireable at will, right? I thought this was terrible, right? I think a lot of people thought this was terrible because basically then you can imagine the director putting pressure on the adjudicators to come out a certain way, or they're getting political influence on how they would decide, right? So the Supreme Court agreed with the Fed Circuit that the structure violated separation of powers, but they remedied it a different way. Instead of making APJs removable at will from the agency head, the court struck down, basically read in that the director had director review over PTAB decision. In other words, by giving the agency head the final say, the court opted to preserve decisional independence of hearing-level agency adjudicators in exchange for more politically accountable over the agency adjudication system, right? And they emphasized, like, look, this is the standard way that we've been doing this in APA. What's interesting in Arthrex, right, is if you looked at this whole series of Supreme Court precedents that was going on, which was basically just chipping away removal protections at all of the agency adjudicators, they paused in Arthrex, right? They put them back in and gave it agency head control. And many people in the administrative law, right, see this as a very good thing, right, because what's happening now is APA formal adjudication is possibly unconstitutional. That's the concern, right? That basically the court's going to say, and this was what was in Jarkissi versus SEC, right? The Fifth Circuit had found that these two layers of for-cause removal protections that occurred in the SEC was unconstitutional, right, and reasoned that the president cannot remove the SEC commissioners at will, and those commissioners in turn cannot remove SEC ALJs at will, right, that prevent the president from taking care of the laws that are faithfully executed. So it's just like, I want to be like, look, we did a good thing in PTAB, right, and we'd love, right, if that could be somewhat simulated and save, I think, APA formal adjudication, right, to say, look, it's just enough to have director head control, right, and at least one layer maybe of for-cause removal protections. So that's all I have. Yes.
Okay, thank you. Melissa's a hard act to follow, and there's not much about which I disagree, but I'm as capable as the next guy of manufacturing a case or controversy. So let's do this. Okay, my sort of sense of where we are after Loper-Bright, and certainly the cases pertaining to adjudicator independence, she has taken the measured under pressure approach. I'm here to raise the hue and cry that we're actually, going off the rails on a crazy train. So let me see how I can set that up. I think Loper-Bright, first and foremost, is a step zero case. It is about delegation. We're much more concerned than we ever have been before about how Congress delegated to the agency, whether they delegated, the scope of the delegation. And these are all questions that ever since Meade have occupied our concern at step zero before we ever get to the statutory ambiguity or the reasonableness of the agency action. So with regard to that, let's step back to the history that Melissa pointed us to regarding Merck v. Kessler, right, mid-1990s, no Chevron deference. There was no real discussion of a Skidmore alternative, which is characteristic of the Federal Circuit's jurisprudence in this regard. It's sort of Chevron or bust, and frequently we end up with what is functionally de novo review of the agency's work. And because, for reasons that folks like Satna Kumar and others have written, it's an expert tribunal overseeing an expert agency with not much, mandate from Congress to act as an expert. And so there's no real institutional appetite for the Federal Circuit to consider themselves as being in need of a deference regime. They can do it themselves. They're inclined to do it themselves. Now, there was nothing even after Meade, I think that's right, but I would go a step further and say not only did the Federal Circuit fail to revisit its Merck versus Kessler approach after Meade was decided, but they doubled down in 2005 and in a series of mid-2000s cases, most notably Starfruits versus SNC. That's where they said not only does the USPTO not have substantive rulemaking authority, only procedural rulemaking authority, and the reason why is that Section 2B2 of Title 35 says that the director shall have authority to prescribe regulations, not inconsistent with law, to govern the conduct of proceedings in the office. Conduct of proceedings sounds here's how it's going to happen, it's very procedural, ministerial even, and so we're much more concerned with the 1-inch margins on your brief than we are with what obviousness means under Section 103. But in Starfruits, they went a step further and said, and when we're differentiating between procedure and substance, here's the line, and you best stay on procedural side of it, USPTO, because we're not going to allow you to, get one past the goalie on the procedural side, when in fact what you're doing is actually abridging the rights and obligations of private parties in a way that we would consider substantive, functionally substantive. So they're very, very concerned at the Federal Circuit that the USPTO not only recognize its authority as being procedural in nature, but functionally contained within what they consider to be procedural in content. Now, what that means is that even within the procedural question, when Melissa correctly says that the Federal Circuit has been very limited as to what deference they will give, this is where the chair throwing and disagreement begins. I'm not sure that Loper-Bright will leave things so much as they were before within the procedural domain. I think it's exactly right that the procedure-substance distinction remains intact. I think it's exactly right that what used to be on the substance side won't change, and what used to be on the procedure side will go down. The place where I diverge with Melissa, I think the USPTO's incentive, and I'll be curious to see what the Federal Circuit does with this, I think the USPTO's incentive is to start testing its ability to make substantive rules and call them procedural. Because now, since they have nothing to lose on the procedure side, they're not getting Chevron deference anyway, what we're concerned with is, were you delegated the authority to do what you want? And what we want you to do, we being Congress. And so let me give you 3 examples, because I see some of you sort of quizzically looking at me, why would the USPTO behave this way? Let me give you an example of a progression where I think they've done just this. In the late 2000s, after the continuation rules that came to a sort of abrupt end with the installation of Dave Kapos as the director, the TAFAS litigation went from the Eastern District of Virginia to the Federal Circuit, and the question there was, were the rules that limited the ability of applicants, to obtain continuation in their examination, it limited them to a certain number, and thereafter you can't have any more. So is that procedural or is it substantive? USPTO said it's procedural, and we have procedural rulemaking authority, and we're entitled to Chevron deference. And also, there's a way to read 2B2 of Title 35 as allowing some sorts of substantive rulemaking authority. All of those arguments in the alternative were put to the Federal Circuit. The Federal Circuit said, no, you are limited to procedural rulemaking authority only, Seamork versus Kessler, and for that matter, Starfruits. But the rules here are indeed on the procedural side of the ledger, so you're okay there. Some of the rules wound up in Chevron land, and they got deference. Now, of course, the entire panel opinion was vacated by an en banc Federal Circuit, and before that decision could be issued, the USPTO pulled the regulation. So TAFAS, the injunction in TAFAS remains intact to this day, but the precedential quality of that panel opinion is 0 because it's been vacated. Okay, so that's the starting point. That's 2009. Fast forward to just this past year, in re Chestech. The dispute in Chestech was a domicile requirement, a domicile address disclosure requirement that the applicant challenged and said, look, by not taking account of the privacy concerns that arise from requiring me to disclose my home address, you're sort of writing a rule that's arbitrary and capricious. I refuse to do so, and by denying my trademark registration on the basis of my refusal, you have imposed upon me a substantive penalty. This is substantive rulemaking, and the fact that you're calling it procedural in form is a sort of shell game. And the Federal Circuit said, no, it is procedural. And so now a pretty substantial right is being being denied, on the basis of something that I think we could see our way to agreeing is procedural. But why was it that this procedure substance distinction was being litigated this way? It wasn't to say the USPTO had no authority to promulgate this rule. We didn't care about the procedure substance distinction because to be on the substance side would be outside the USPTO's authority, and to be on the procedure side would be inside the PTO's authority. That argument wasn't even made in Chestech. And that's what gives the PTO the opening that I'm describing. The reason Chestech litigated the way it did is that if it was procedural, you would not need to engage in notice and comment rulemaking. If it's substantive for APA purposes, you would need to engage in notice and comment rulemaking. And the USPTO made some interesting arguments. They said, A, it's procedural. Therefore, we don't need to engage in notice and comment rulemaking. B, even if it's substantive for APA Section 553 purposes, we still wouldn't need to engage in notice and comment rulemaking. And the Federal Circuit ultimately said, well, no, it's procedural, you're on solid footing there, and you don't need to engage in notice and comment rulemaking because the exemption in 553B applies. So now, although Chestech was fundamentally a case about do you need to engage in notice and comment rulemaking or not, which, by the way, is also another step 0 question of the sort that we're not done caring about after Loper-Bright. Because not only do you have to be given the authority to speak with the force of law, whatever that looks like, you also have to have committed your agency action, promulgated your rule in the exercise of that action, of that authority. And the way most times you do that is by engaging in notice and comment rulemaking. When the Federal Circuit decided en banc in Aqua Products versus Mittal that the burden shifting of proving either unpatentability or patentability of amended claims during inter partes review by preponderance of the evidence, what they said was, yeah, the PTO has this authority, and they have exercised that authority, and they're able to speak with the force of law, and they did speak with the force of law. Another group, another sort of faction of the Federal Circuit said, no, they don't have that authority, and so no deference. And then there were two judges in the middle, and they were the ones who made the difference, that said the PTO does have this authority, but they didn't exercise it in a way that is APA compliant, and for that reason, they don't get Chevron deference. So is it procedural or substantive will matter immensely going forward, because that's all there is left to care about after Loper Bright. And whether it's substantive or, whether it's procedural or not also matters after Chestech to whether they need to engage with that authority in a way that is APA compliant. Are they exercising that by doing notice and comment rulemaking? Are they not exercising that authority by doing it some other way? And the middle ground between TAFES and Chestech is COSO. Incidentally, the case that the Supreme Court called out in Loper Bright as being the last time they've ever used Chevron deference anyway. This is a doctrine that's on its last legs. It's not really used to make that much decision, do that much decision making anymore anyway, so let's just put it to bed. Well, in COSO, as Melissa pointed out, the sort of authority in question to promulgate a rule that made PTAB claim construction be carried out under broadest reasonable interpretation versus the Phillips standard that is used in the district courts. Well, the authority to promulgate that rule and govern PTAB proceedings came not from the general rulemaking power that the PTO has under 35 U.S.C. 2b2, but a much more specific PTAB-focused statute, 35 U.S.C. 316a4, which doesn't say govern the conduct of proceedings. It says prescribe regulations to establish and govern inter partes review. Not the conduct of proceedings, just inter partes review. So that's procedure, substance, everything. They have that authority, they've been delegated that authority, and that is ambiguous enough, even if 2b2 is unambiguous, as many had argued prior. It unambiguously grants the PTO only procedural, not substantive rulemaking authority. 316a4 is sufficiently ambiguous that you can go forward to step 2 and ask, is a BRI claim construction standard reasonable? And of course, the Supreme Court said yes, perfectly reasonable. And it would take a couple more years before the USPTO, by rulemaking, changed its mind and went from BRI to Phillips. So suppose for a moment that a rule such as claim construction, not in the PTAB context, but just generally, in ex ante patent examination before examiners, okay, is a rule that says you have to use the Phillips standard in ex ante examination, or BRI, as we currently do in ex ante examination, procedural or substantive. I think it could go either way. It could go either way, and it could go either way on two different axes. One, it could be procedural or substantive for 2b2 purposes to decide whether it's within the ability of the USPTO to promulgate in the first place. And it could be procedural or substantive with regard to Section 553B's exemption that it needs to happen through notice or comment rulemaking or not at all. And if it's procedural for one purpose and substantive for another, then it might be ultra vires or not. It might be subject to some kind of deference or not. But fundamentally, what we're concerned with is the step 0 question of what is the nature of the authority that the PTO has been delegated, and what is the scope of that authority that the PTO has been delegated. That's the test case that I've got my eye on, and my money is on the PTO trying to be a little more muscular than they have in the past, and as, for example, folks have urged them to be. So starting there, let me turn now to the adjudicator independence point, which I think also is closely connected to the way in which the USPTO will exercise its powers. So adjudicator independence is under strain. That's in tension with political accountability and political responsiveness and so forth. I think the hiring and firing question is an important one. I think what I'm also concerned with, and this is the subject of some empirical research I've done recently, is about setting aside how you hire and fire them once they're in the core of judges, and the board is, usually the numbers are fluctuating between 200 and 300 people. How do you take this large group of extraordinarily intelligent and well-qualified people and empanel them in a way that will account not only for their subject matter expertise, as the law requires them to be technically proficient and not just legally proficient in patent law, but workload. And if there's a lead judge, this is an important case, we want to lead APJ on this, not merely, quote unquote, merely a junior APJ, or something like this. The manner in which it's impaneled is highly opaque. The factors are set forth in the standard operating procedure, but for the most part, I think the action is going to be in how judges are impaneled once they're already part of the board, and re-impaneled, because of course panel stacking is something some of us might be old enough to remember personally. The way in which the director exercises control after a decision's already been made is, at that point, the die may already be cast in a lot of the ways in which the review, the subject of review is fixed. The legal questions have been adjudicated, the fact findings have been made, but if before a decision comes out, and there was some instances of this where it happened prior to, I think it was 2 administrations ago in the PTO, the decision's about to come out, we know it's going to come out in a way that the PTO leadership considers quote unquote wrong, and so let's stack the panel with 2 additional judges. There's one case in which the 3-judge panel was going to be unanimously coming out one way, and leadership doesn't like that, so they add 2 more judges and say, okay, these 2 judges are going to vote the right way, and all we need is to flip one of the 3 original judges. And then it'll go 3-2 the right way, and everything will be fine in Neverland. But the original 3 judges hold their position, and now we have a 3-2 decision going the wrong way. So what do? We double down, and the PTO adds 2 more. And now we've got 4 judges who've been added since the beginning of the panel to vote the right way, and the 3 original judges still won't yield. They write a dissent holding to their original position, and it's 4-3 going the right way. That may be good as a matter of policy. It may have gotten the uniformity of the agency's voice well in line. I think that is extraordinarily bad facts when it comes to what the agency is going to do with the adjudicator independence that they do have before we get to the question of how it's going to be preserved. So I don't think I disagree that adjudicator independence is quite important, but the details of impaneling are also going to be quite important as we go forward in setting this policy. So that's where I'll leave it, and I look forward to Melissa's rebuttal.
Wasn't great, right? And argued in that paper with Chris Walker about, right, in the new world agency adjudication would be much better off, right, just doing director-head review for a bunch of different reasons. One thing you said that I was puzzled by, that I didn't quite understand, is why do you think the PTO is going to start making substantive rules and say they're procedural? Personally, I think agencies always kind of have some incentive to do that, right, to get out of notice of comment rulemaking, right, for the PTO to get deference beforehand, right? So I just didn't quite follow why you thought that would ramp up more now, right? Like, is that something they always were doing, or how's that really to look right?
So I think, so let me begin with how it's related to local rate. The reason why it's going to ramp up over and above what we might already see is that they have less to lose by shorting up what's clearly procedural. There's nothing being procedural doesn't get the shut on this anymore. So all that's left is this within our power to promulgate at all? And if it's within our power to promulgate at all, there's no reason to sort of not dilute their procedural ruling authority and ask for shut on evidence for that, because they're not going to shut on anything. All that's left is to make whatever rules they think they can get away with and call them procedural. They get the margin vastly set. Now, I don't think it's going to happen, like off the charts, but I think at the margin that the direction of the executive is they'd be more substantive than they used to be, and call it procedural. Because that's the only thing left to do.
I'm conscious that we're about 20 minutes from beginning the next panel, so I don't want to extend this too much, but I think maybe we might have time for one question from the audience, if anyone has something they'd like to ask our twins.
So I'll ask the first question. I think I agree mainly with Melissa. Not surprising that she earlier admitted that I taught her administrative law.
Yes.
So Saurabh, I guess that your parade of horribles, and maybe it doesn't have to be a parade of horribles, but is that agencies and the judicial system will focus more attention on the delegated authority. Again, now with all the Chevron stuff is just completely off to the side. And I would say, that's the best of all possible worlds. And the poster child for why that is the right way to go is local right. Because in local right, the first section of that local statute had a section in it, subsection in it, that said the agency only had the power to issue guidelines. And just in case nobody thought that was clear, the people who don't take ad law don't know what the guidelines are different than rules, Congress went back 2 decades before me and added a parenthetical that said, and I quote, that shall not have the force and effect of law, which I've never seen anywhere in administrative law. Somehow, the Circuit Court of the United States gave this entity Chevron deference. It just because people were so focused on those wildly complex common law, judge-made law, they weren't asking the very, very basic questions of administrative law. How much power did Congress give this entity in a particular statute? And now the Justice Department, or the PTO, when they're defending an agency, has to look at the statute and defend the ground that we've got this much authority, we've got the authority to do that. And maybe in regulating inter partes reviews, for example, they do have a lot of power, but that's kind of sort of a specific interpretation about delegation, which is where it should be. Don't you think so? I mean, that's the best of all possible worlds. I'm very happy with this, right?
Yep. I do, and I am. So
I think your mic's off.
Okay. Yeah, I do agree. So with regard to the IPR regulatory ruling, right, the 316A, in CUSO itself, whether the ability of the agency to prescribe a claim construction standard for PPAC trials was procedural or substantive did not matter, because there was no limitation in 316A4 that said it's limited to procedural rules. And of course, the agency did undertake notice of comment rulemaking. They wouldn't have done it any other way, for instance, political transparency or stakeholder accountability. So again, not in dispute. Now that that power is, and so that's why I was trying to be careful to caveat that if that plan construction dispute from CUSO had taken place instead under the 2B2 authority, things would have been quite different. So I think you're right that quite different in so far as setting up a test case. There was no possibility of CUSO being that kind of test case because it was clearly within the authority of the agency to rulemaking, and it was clearly satisfying any requirements of notice of comment rulemaking because the agency did so. If it took place instead under 2B2, then whether it's procedural or substantive matters a great deal to 2B2A, and matters a great deal to 553B on notice of comment rulemaking. So I agree with you as far as that goes. And if the sort of broader systemic point is that the USPTO is now going to, like all agencies, get more clear, narrow delegation of authority from Congress, so much the better as well.
All right, well, that gives 15 minutes for folks to get to the next panel and do today's Wordle, so I think we're probably going to call it there. And if you'll join me with thanking our evil twins.
So thank you, University of Richmond, for another wonderful Evil Twins debate.